All right. Welcome back, everyone. We're live here. This is Craig Steger. For those of you that don't know me, I'm an attorney. My main office is in Wisconsin, but I also practice in Iowa and Minnesota. And I'm doing a later live stream today. I'm actually in Georgia. And good to good to see you again. How are you doing? Are you out near the fires? Are they? I hadn't really heard anything about it, and all of a sudden I checked the news, and it's everywhere, everywhere out there. So I hope you're not in the region where the fires are going on out there. Sounds like a very scary deal. I am. So I'm actually in Georgia tonight. I'm in a hotel. Let's see if I can get. You'll just have to put up with the background. So before we begin, let me just get the legalese stuff out of the way here, and then we'll start talking about today's topic. Because this is a live stream and anyone can participate in real time with me, just recognize that this is for informational purposes only. This does not constitute legal advice. Viewing or participating in the live stream does not create an attorney-client relationship. You should always consult with an attorney directly about any legal questions you have, and make sure that they're licensed in the state that you're in and that they handle the kind of matters that you handle. So if people have particular questions related to Wisconsin, Minnesota, or Iowa, feel free to go into the description after the fact and send me a message. You can also always call or text me, 608-205-8826. I do my best to respond to those as quickly as possible, but you can also reach out to me that way. With that out of the way, let's get back at it here. Yeah, so the fires, have they figured out what started the fires yet? Sounds like it's sort of affecting a lot of the wealthy neighborhoods and the big houses around um, um, LA or whatever. My son is just south of there, Southern California. We're supposed to actually meet with him next weekend. We'll be in Arizona, and we're going to bring him over for a few days. So I hope he's able to still come and do that with us. You should consider doing a series on consulting, because many attorneys won't do it here in California. Maybe they're so busy. Do you mean just doing like just answering people's questions, or picking? We call them cold calls. Someone randomly calls us. We call that a cold call. Is that what you mean? I know that when I was a young attorney, people still looked us up in the yellow pages. I don't even think we carry yellow pages ad anymore because no one really uses those. But still, we get most of our traffic from word of mouth, referrals, things like that. Yeah, I hope they. And maybe it's hard to tell. Fires are a foreign thing to us from the Midwest, so hopefully they can figure it out. Sounds like the winds have been really bad. If I'm hearing the news reports correctly, it sounds like the winds have been very bad out there. Interestingly, yesterday when I came in, so I flew in from Wisconsin to Georgia. So I'm in southern Georgia. And I was on a plane with a lady from Arizona who was coming out here. Who they do crop insurance she works for a crop insurance company, and they were training some agents here. And it sounds like there was a lot of crop damage in the southeast part of the country with the two hurricanes that came through. I think she specializes in cotton and what'd she say? Cotton and I think some nut trees and stuff like that, which I don't know anything about. Um, so anyway, uh, it's of course, agriculture is very different out there in California too, where you got to deal with wildfires and stuff like that. So um, I hope they're able to get the fires under control quickly, and that people can, hopefully return safely to their homes and businesses as soon as they can. So, um, so I'm in Georgia tonight. I fly out first thing in the morning, back to Wisconsin. So I'm in Georgia for a deposition of one of my experts, one of my witnesses on a malpractice case. And so it's me, and then there's two other lawyers, because the way it works in Wisconsin, this is unique to Wisconsin, but the way it works in Wisconsin is hospitals and clinics have a requirement that they maintain liability insurance or malpractice insurance of $1 million. And they're not required to cover more than that. And if someone has a claim where the damages exceed $1 million, in Wisconsin, we have something called the Victim and Families Patients Compensation Fund or something like that. I'm sure I'm messing it. We call it the fund. The fund in Wisconsin is sort of an excess insurance policy, sort of, but it's not an insurance company. It's literally a huge pool of money, operated by, I think it's in combination between the Wisconsin court system and the board, or the entity that regulates and licenses hospitals and doctors and things like that in the state of Wisconsin. And the way it works is hospitals and doctors carry $1 million of liability insurance, and then they pay in I don't know how they got some formula for deciding, but they pay in additional money into this fund. And I suspect the amount that every doctor or hospital pays depends a little bit on the area of medicine that they practice. Some areas of medicine are higher risk for claims than others. For example, a family medicine physician probably pays less in these premiums than, let's say, a doctor that does OBGYN, so like cares for pregnant moms and giving birth and all that, which is, I think, one of the most probably one of the most expensive areas of medicine to insure, because when something goes wrong during a delivery, and let's say a brand new baby is born with permanent health issues, it can be very, very expensive, and just a lot of crazy things can happen during labor and delivery. I know that as a father of many kids. But they pay into this fund, and so the fund is essentially there to cover excess verdicts and judgments. The problem, if you want to call it a problem, is that the fund hardly ever pays out because so few people succeed in these kinds of cases, such that I believe during COVID, they actually waived insurance premiums for doctors into the fund because they had so much money built up that they didn't need to recover any premiums. and there was a big fight here in Wisconsin. It must have been 10, 15 years ago, where the fund had grown over like $2 billion. The corpus of the fund was over like $2 billion. And I think the legislature had tried to dip into that fund and pay for roads or something like that. And then they made them pay it back. So this huge fund in it, and it generates interest, like you say here. I would almost guess that it's large enough to grow without additional premiums. But I don't know. I don't know how it works. I actually tried to get on the board of advisors for that at one point in time, which I might try again. But, so Wisconsin, medical malpractice cases are very, very difficult to win and expensive to try in all states. But Wisconsin, I believe, consistently ranks near the very bottom in terms of being one of the worst states for people to have malpractice claims, because of a whole confluence of factors, some of which I'll talk about tonight, that make it a very hostile environment for people to bring medical malpractice cases. So, for example, they're very expensive to try, and that's pretty much true anywhere. They are very difficult to win. The defense wins the majority of cases that ever get to trial. So there are damage caps. The damage caps have been challenged in the past when they were small. Excuse me, when they were smaller. Supreme Court ruled it unconstitutional. I think they used to be like $250,000 for pain and suffering damages. So that's non-economic damages. Basically, there are two categories of damages, and this is true in any kind of personal injury or medical malpractice case. We have economic damages, which are things that can be quantified, things that have price tag, if you will. Medical bills, lost wages. Let's see, if you have to like modify your vehicle, modify your house with handicap ramps and stuff like that, all, those kinds of things that are quantifiable are called economic damages. And non-economic damages are pain, suffering, and disability, sort of the intangible ones. I was checking my text messages because I'm going to pick up the defense lawyers from the airport, and I mentioned that I might live stream tonight. So I was curious to see if one of the defense lawyers had shown up on the live stream, because I do be careful about what I say tonight. So Wisconsin has a damage cap of $750,000, which may seem like a lot of money and it is in I guess in the great scheme of things, but in medical malpractice cases, $750,000, if you have a lifetime of really difficult suffering, life altering type things, that doesn't go very far. And what it does do is it strongly discourages malpractice cases. There's no cap in Wisconsin on economic damages, so like future medical expenses, things like that, although there's something built into the statute about medical expenses over a certain amount, like the fund pays. I don't know. I've never actually had a case that had that happen. So what did I say? So, they're expensive to try. They're difficult to win. There's damage caps on non-economic damages. There's actually attorney's fee limits in Wisconsin that make it really difficult for most lawyers and law firms to financially even take a chance on one of these cases. There are There are special evidentiary favors that malpractice defendants get that the average insurance company doesn't get. The one that stands out is called the collateral source rule. The collateral source rule basically, so in most personal injury or malpractice cases where there's medical care, there's two different figures, okay? The one figure is, let's say, the billed amount, the so-called sticker price for medical expenses. Most of us never pay the sticker price for medical expenses because there's some sort of a discount. There's a discount built in, such as even cash payers usually get a discount. I don't know if anyone actually pays a sticker price for most things, but it's, if health insurance companies have provider agreements, they get a discount. Medicare has mandatory discounts so that, what is it, 20% on average, probably, of the actual billed amount is how much Medicare pays. So you have what was billed and how much was actually paid, okay? And in Wisconsin, in non-medical malpractice cases, the injured person is allowed to claim the billed amount or the sticker price, which is, like I said, often much higher than the paid amount, because it's viewed as that's a collateral source. So if I go out and I purchase health insurance, and my health insurance company has negotiated a discounted rate with the hospital, that benefit should go to me, not to the defendants who caused the crash. So in the general rule in Wisconsin is that the collateral source rule says that the defense does not get to introduce to the jury how much was actually paid to the medical expenses. Rather, the jury hears how much was the quote unquote sticker price, provided that reflects the fair market value of those medical services. So the collateral source rule is an evidentiary rule that prevents the defense from introducing evidence that health insurance or some other fund, maybe a family member, whatever, paid for some of the medical expenses or at a reduced rate. Well, the malpractice lobby in Wisconsin got that rule changed for them. So if you have a malpractice case, they actually get to claim, or at least get to introduce to the jury the amount actually paid, which it makes it impossible for the most part for plaintiffs to claim the billed amount, because they want to try and make it look like the plaintiff is being greedy. They're trying to get more money than the hospital was actually paid, and so most of the time plaintiffs don't even pursue the medical expenses or just concede to the much reduced amount, because otherwise it makes them look bad in front of a jury. So it's a very powerful tool that the defendants have in malpractice cases in Wisconsin. So all of those things, in I guess the other one that I would mention that is similar to one of the other factors is because they're difficult to win, is because juries tend to be very willing to give the benefit of the doubt to hospitals and doctors, and are very suspicious and have a bias against injured people and their lawyers, plaintiffs' lawyers. And so it's one of those things where there really isn't a malpractice. Well, there isn't a malpractice lawsuit crisis in as much as there's too many of them. The real crisis is there's far too few of them. And for me, 99% of the cases that come to me that I look at, I turn down because I just can't. I don't know that we can win, right? And even the ones that you take, you recognize that there is a chance that you could lose. So that's a long way of saying that in Wisconsin, at least, medical malpractice cases are very rare. Okay. So I have one that kind of got through all that. And so we're in suit. And what's interesting in Wisconsin, I don't know exactly how this compares to other states, even Minnesota and Iowa, where I don't know that I've had any medical malpractice cases in those states. None come to mind. But in Wisconsin, at least, I always say the first nickel is the hardest one to get, and after that, it's just dollars and cents. Because in most of the time, medical malpractice cases that go to trial in Wisconsin, the insurance company has not offered a single penny. As crazy as that sounds, they will go on to trial without offering a single penny. The excuse that they give, maybe it's true, maybe it's not, I don't know, but the excuse that they always give is that they're required to report any payout, whether it's a jury verdict or a settlement, to a governing body. I don't know if it's unique to Wisconsin or if it's a broader area than that, but they claim that they have to report any settlement to this agency, and if they get too many of them, they can lose their license and things like that. I don't know if that's true or not. I strongly suspect there hasn't been a single doctor that's had their license taken away because of that. I believe the genesis of this process was the idea that we want doctors and hospitals to self-report settlement and things like that, so that the people know who the doctors are that have settled malpractice cases, right? I think it was ostensibly created with the idea that it's going to improve healthcare quality and improve patient care, when it really doesn't really have that effect. What it does do is it makes it almost impossible for cases to settle, because according to them, if they pay $1 or $10 million or go to trial and lose, it's the same. It's one reporting to this agency. And since they know they have a statistically good chance of winning them anyway, let's roll the dice and try to avoid a reporting. That's the excuse that they give. And it may very well be the case, because they take a very illogical, in my opinion, or at least inefficient approach to litigation. So when COVID happened, prior to COVID, in any kind of litigation case of any potential magnitude or value, it was normal for us to travel, get on an airplane, and go wherever someone had an expert witness, take their deposition testimony, maybe record it, and gather that information, report to our clients. And a lot of that was done in person. For a time, you had to do it in person. And then COVID all kind of changed that, and we realized that, you know what? We actually don't have to travel across the country. You don't have to sit in the same room with them. You can see them on screen. It used to be otherwise. Your options were in person or telephone, and telephone wasn't a very good way to take depositions, because you couldn't see what was happening in the room, what the witness was looking at. With Zoom, you can tell. You can more or less tell what they're looking at. And so Zoom has pretty much, for the most part, any of my other non-medical malpractice personal injury cases, I've got a large trucking case, for example. All those depositions are being done by Zoom. You can actually get doctors to appear by Zoom at trial. It's just become very commonplace. But in medical malpractice, for whatever reason, the insurance companies or the lawyers still sort of operate under a pre-COVID idea that I got to be there in person. So what does that mean? Well, all three lawyers in the case are in Wisconsin. We all got on an airplane. We flew down to Georgia. We spent yesterday traveling. Today so we all stayed in a hotel. We all sat around for most of the day. I got other work done. But then we went to this doctor's office, very busy clinic. He was on and off his phone the whole time. They charge a lot of money. The doctors, as they should, charge a lot of money for their time. And then we all are going to spend another night in a hotel, and we're all going to get on the same airplane tomorrow and go back. So, it's thousands and thousands and thousands of dollars that are being collectively spent to go through this process, and we'll do it all over again every time with all the witnesses. And so it is not unheard of for cases such as this to cost tens of thousands, if not hundreds of thousands of dollars to bring. Those are actual, that's just costs of hiring doctors, witnesses, traveling, depositions. That's really doesn't even include the attorney time, which, on our side, on the plaintiff's side, we're typically doing on a contingency fee cases, whereas for the insurance company, they're paying these lawyers by the hour, right? So they're going to spend a lot of money doing this when it could be done by Zoom, or perhaps put that money towards a settlement, but that just doesn't really happen. Let's see. Yeah, you don't always have to pay the treating doctors, although oftentimes we do now. But most of the witnesses that testify in these kinds of cases are not treating doctors. This may seem, I don't know if this is surprising to people or not, but when malpractice happens, it's common for someone to find out because they went and saw another doctor who fixes the mistake of the first doctor. Those other doctors, the ones that figured it out, invariably will not testify against a colleague or someone else, a competitor even. And in fact, in Wisconsin, they have what's called an alt privilege. It's ALT. It's based on a Wisconsin Supreme Court case, which basically recognizes the right of a treating physician who has not agreed to be retained for a case, gives them the right to not give up their own personal opinions about whether another doctor was negligent or not, even if they hold those opinions. They're basically allowed to keep opinions to themselves, even if they form them. And that's usually what they do, right? They usually don't. They're like, I'm here to treat this patient. I'm not interested in getting involved in your lawsuit, no matter what I think the other doctor did wrong. And so you have to go out and hire doctors. And not all doctors are willing to do this kind of work. And fewer doctors are willing to represent the injured plaintiffs than those that are willing to represent the defense and come to the defense of the doctor, hospital, or other healthcare provider being sued. And they charge a lot of money because their time is valuable. You take a surgeon away from doing surgeries for a day, someone has lost a bunch of money. They want that money, and so you have to pay them. And so it's just very, very expensive for these cases to be brought, and they're expensive to hire the lawyers, to travel, and all that kind of stuff. And what's frustrating to me about the whole situation is that what it means is even, I had a slip and fall case in the recently that I settled that could have been a $0 case. The jury could have found that my client didn't slip on the defendant's property and they would have gotten $0. But because it was a bad injury, we were able to get the insurance company to pay a lot of money, like a lot of money, because the damages were such that the worst case scenario for them was pretty bad. And so even in those kinds of cases, and this wasn't nuisance value, but usually you can at least get nuisance value, which is if it's cheaper to settle the case than to hire lawyers and defendant, then insurance companies recognize the economic realities of that. But those rules don't seem to apply in medical malpractice cases. They tend to they will spend as much money as it takes to defend the case, but typically don't offer that first penny for the reasons that I've talked about. And so that's just one of the other reasons why lawyers are very reluctant to take these cases, understandably so. When I take on one of these cases, after I spend a lot of time looking at it and talking to doctors and experts, making sure we have a case and it's very strong, when I take on one of these cases, I fully assume I'm going to have to try this in front of a jury at some point in time, which isn't really the case on most other types of cases that are not malpractice. I know that there's a really good chance that the case is never going to go to trial. The vast majority do not. And so even if there are weaknesses in your case, you can still usually get a settlement for at least something reasonable. That doesn't tend to happen in malpractice cases. That's just the unfortunate reality of medical malpractice cases. They really, in my opinion, ought to just scrap the whole system and go to some sort of a no-fault system. Canada, as I understand it, has some sort of an administrative system, probably similar to workers' compensation here in the States, but it pays out more money more often so that when people do experience a bad outcome in the healthcare system, they actually can get some compensation, and it's not just kind of that 1 in a million person that has a really severe injury, a really obvious case of negligence, and can find an attorney that's willing to take the case and then go to the trial and actually win that case. I don't know what that's all about. I guess I don't have any experience with that. I would love nothing more than the government to come in and take on malpractice cases for me so that I didn't have to do it. But that's not the way it works, at least not here in the States. So, so I'm I enjoy the medicine. I enjoy it's an interesting area of practice, medical malpractice, but it is not for everyone. And the biggest mistake you can make as a lawyer with medical malpractice cases is taking a case that you shouldn't take. I've never regretted a case I turned down, but I've regretted a number of cases that I took on. That's just the way it works. But someone has to do it, so I continue to do it. So I try to make the best of it. So, yeah, I'm down here enjoying Georgia. Going to travel back tomorrow, and then get back at it. So, let's see here. Got a couple. Is that the case in California? I have not heard about that. And if it results in any payment of money, I have not heard about that at all. I'm not sure what you're talking about, then, because I've never seen that. Maybe if it's a case against like a state hospital, or like the VA system. So if you sue the VA system, I believe you have to go through the Federal Tort Claims Act process. I'm not sure. I've never had to do that. Well, in California, has your healthcare system is that whole Kaiser Permanente thing or something like that. I'm not sure exactly how that works, but I've heard about it. Okay. Yeah, I think California is a bit of an outlier compared to the rest of the country, or vice versa. California, I think, operates very different from a legal standpoint than most other states. Certainly, rural states. Maybe New York is probably a little closer to California, and I think I believe there was damage caps in California too. I think those just recently got raised. I think Nick Rowley, I believe it was California. Yeah, pretty confident California raised their damage caps recently. Nick Rowley, who is a lawyer I've done cases with in Iowa, does a lot of work out there, and I believe he spent a ton of money helping to get the damage caps changed. The damage caps are a real problem in states because they're often done without a lot of thought about what it does, because it is so expensive to try malpractice cases, and the chances of success are fairly low compared to other kinds of cases. You really do need to have the possibility of a catastrophic injury verdict to justify that kind of risk. And when you have those damage caps that, $750,000, for example, to a cap in Wisconsin, well, if the most that you can recover is $750,000, it's hard to take on a case where you might spend $200,000 or $300,000 trying the case and possibly lose all that. Like that's the mathematical problem with damage caps, and it would have to be a much higher damage cap. Maybe $5 million would make it a little more feasible, but it is what it is. It's to the point where it's going to be harder and harder, I believe, to find lawyers that are even willing to do medical malpractice cases. And I only have one, I believe, one active one right now, and that's about all I can handle with my caseload. They're just very time consuming and expensive and stuff like that. So yeah, so that's the truth and reality of medical malpractice lawsuits. And I'm kind of a Debbie Downer when it comes to this stuff, but it's the reality of it. I think people are starting to wise up a little bit to it. The whole tort reform stuff, I think people are a little more skeptical of that, but it's a real problem. People are constantly told that jury trials, malpractice verdicts are going to be raising insurance premiums for doctors and stuff like that, and it doesn't really seem to be the case. What's the most time-consuming part of your cases? It is probably just the amount of study that it takes It's not like I can just I can't just take a doctor's deposition by reading some Wikipedia articles ahead of time. You have to kind of really study the medicine in great detail, learn the terminology, learn the anatomy, that kind of stuff. Like, for example, the one I'm here today is a spinal surgery. Okay. So it involves a spinal surgery. And so I really haven't had a spinal surgery case. So I'm trying, you have to learn about, the vertebrae, the different levels. So you have cervical, thoracic, lumbar, the different components to the vertebrae, the different procedures. There's terminology for everything. All of that is completely foreign to me, or was until I started this case. So that's probably the most time consuming part of it. And also, because to have one of these cases, it takes kind of catastrophic injuries. There tends to be just a ton of medical records. I think we have over 20,000 pages of medical records in this case, and it might be closer to 25,000 now. I don't read all those, but you have to be acquainted with them a little bit. So that takes a ton of time. And it's this kind of stuff. It's 3 days, 3 days basically out of the office, 2.5, 3 days spent out of the office to do what, and that's really without preparation. I don't have to prepare for this one because I'm not the one taking the deposition. But just three days to travel and be here for what amounted to 2.5 hours with this witness, right? So it just takes a lot of time, just the traveling alone. And if when I'm doing this to their doctors, I will spend days preparing ahead of time, going through material and stuff like that to get familiar with it. Yeah, I mean, I think most lawyers care about their clients. You kind of have to. I do. It's one of the reasons I do malpractice cases, because at least in where I'm at, there just isn't very many lawyers that do it. And if I turn the case down, they probably won't find a lawyer. And when I see something I think that was really bad happen, um, I do like to try and fight for people, even if it's a very uphill battle, and it's not a very good use of my time from the standpoint of I could make much more money and try to make much more money on other types of cases, car crashes and truck accidents and things like that. You ever thought about working for government as a lawyer, and what makes you not? Not really. Not now. Maybe early on, but for now, I would have to sacrifice a lot of like personal freedoms to go work for the government, and in pretty much every scenario, I would take a pay cut to do it. The benefits would be better, the security's better, but you tend to make a lot less money in government. I have a big family to take care of. And the only thing I would possibly consider would be running for judge someday. But there again, it would be maybe when I get a lot older, maybe I would be interested in that. But it would be a different change of lifestyle. The freedom and flexibility to pick my work, you kind of lose then. You have to do all the stuff, the cases that come in front of you. Now I get to kind of pick and choose a little bit the type of work that I want to do. So I do like being in private practice. As it's difficult. I mean, you gotta, work for the government. You don't really have to like find clients. You don't have to find work. It's there for you. So that's certainly a benefit to government work, that those of us in private practice don't have. But so anyway, well, that's kind of what I wanted to chat about tonight. I actually have to wrap this up. I have another live stream on another channel to get to. It's been tough to get the live streams in because I've been with the holidays. It was crazy, and then with this week, like I said, I've been on the road. I might be able to live stream tomorrow. We'll see. But yeah. So anyway, wanted to throw that out there. If people have questions after the fact, especially about medical malpractice, I'm always happy to try and answer those questions. I prefer, if I can, to answer questions in video instead of a lot of phone calls, because it's just, unfortunately, there isn't much I can do in the vast majority of those cases. So that's why I like to do videos on it, to help answer questions as best that I can for people. So yeah, I appreciate that. Keep safe out there. I hope they get those fires under control quickly. And then, yeah, I'll probably see you tomorrow. So anyway, appreciate everyone watching. And until next time, everyone, have a good one.